So this panel is organized by Rónán from NUI Galway, and also by the Ryan and Whitaker Institutes, and by the College of Public Policy and Law from NUI Galway. So the reason why we decided to set this panel up is the fact that we have remarked that there's increasing use of information and communication technologies for purposes of environment protection. So a very good example is the EU policy for ICT for energy efficiency, which uses ICT for smart meters, smart grids, but also smart buildings, smart cards, and smart cities. There are also other examples like the new EU Copernicus satellites, which monitors the Earth and gathers information about climate change, or also the so-called Xively initiative, whereby citizens equip themselves with sensors to detect the quality of air in Newark and Amsterdam. And we also found that in the privacy communities, these issues have received very little attention. So, and when they did, they were only from a exclusively privacy perspective. And so our feeling was that there was a need to understand also the environmental side aspects of all these use of information communication technologies. And so this panel is a first step, a first attempt in understanding these links between privacy and environmental protection. And so to discover these issues together, we have the following speakers. So we have Martina Hennessy, who is a senior manager of the informatics team within the Irish Environmental Protection Agency. And I think you will tell us about, give us an overview of the use of ICT at the APA, and what are the efforts to make this data visible and transparent. Then we also have Andrew Jackson, who is a natural environment officer within the environmental NGO called, so how do you pronounce this? Taisce, which is the National Trust for Ireland, and I believe that you will tell us about the use of satellites, data, and drones for environmental enforcement. Then on the other side of the table, we have Burkhard Schafer, who is a professor for computational legal theory at the University of Edinburgh, and who is director of the Script Center for IT and IP Law. And Burkhard will tell us about, let's say, classical or more classical privacy issues, and see how they apply in this context. And so in particular, he will tell us about the digital divide and what are also the values in these information systems, what are the biases, what is being overlooked. And finally, we have Guido Gorgoni, who is a professor at the University of Padua in Italy, and he is a teacher. He teaches legal theory and legal computer sciences. And his presentation will focus on the smart meters and the EU policy of responsible research and innovation. So before I give you the floor, may I just ask the speakers to respect the 12 minutes per presentation, quite sharp, so that we have a chance to get questions from the public. And so, yeah, Martina, I give you the floor.
Thank you very much. I'm very happy to be here and welcome the opportunity to talk to you today. So I'm going to just give an overview really of how an environmental regulator uses ICT, and I'll outline some of the challenges in that space and some aspects of our work that may be relevant for the discussion here today. So just to let you know, the EPA was established in 1992. It's a relatively small organization in that we have around about 340 staff. We're all about, our mission is up there on the screen, it's all about protecting the environment, and we have a number of different functions that enable us to do that. We are distributed throughout Ireland with our headquarters in Wexford in the southeast of the country, which is where I'm based. And majority of the staff are very technical in different areas, so we're talking about both science, IT, and engineering, with the remainder, the 30%, in more administrative type roles. So just to outline some of our roles and responsibilities, so we have a lot of legislation that we are tasked with in implementing. Some of the key ones are listed there on the screen, but there are many others. That's not an exhaustive list. There's lots of legislation that we have to work with. And in terms of what we actually do, well, our core functions are very varied as well, but a core area would be around licensing. We have a number of different regimes that we implement, and then we look to enforce those licenses as well. We're responsible for reporting on the state of the environment, so that means doing a lot of monitoring work, assessing the quality, and then reporting on that. We have roles in other areas such as in education and outreach and promoting environmental policies. We monitor greenhouse gas emissions. We manage a very large research and development budget on behalf of the state. We look at other areas like waste management and also radiological protection. So our roles are very wide-ranging. And if I talk about ICT in this particular context, it's actually very difficult to summarize because it is so pervasive in just about everything that we do in the organization. So our budget for ICT is about 10% of the overall budget, which is higher than the norm, at least in Ireland. In the public sector, the norm would be closer to 5 or 6%. So our investments are very significant. And about half of that goes into just managing and maintaining existing core infrastructure, so things like our website, email, basic finance systems, etc. But about 50% every year is around new system development, which is fairly substantial. And there's a lot of different areas. Just about every aspect of work that we're involved in has some kind of IT component to it. But just to mention a few, for example, automated risk assessment. So we're very concerned in a lot of our different functions, we're looking at environmental risk. And as part of that, we want to integrate and pull together as much data as we can that will help inform our assessments of where the true environmental risk is, because where we have limited resources, it always makes more sense that we're targeting those resources in the most effective way. And so to do that kind of work, we're talking about a lot of data integration, but also using technologies like spatial analysis, GIS, location-based data. So that's a very core component to a lot of the work that we do. Just to mention another couple of examples, we have the Environmental Data Exchange Network, which is a shared service that we have developed, and we manage and maintain that. So that's used as a platform for us to work with a lot of other public and local authorities within Ireland. So we use that as a way to exchange information in a more efficient and structured manner. So for example, where we have a number of different local authorities, we can get all the information that we need from them in structured, standardized ways, rather than individually having to go out to them and negotiate on formats, etc. So that has been in existence for about 6 to 7 years, and it's certainly a platform that we're looking to expand and to get more organizations involved in using. So those examples are very much from a sort of internal perspective, but a key aspect of our work is about reaching out as well and disseminating information. And so we've some aspects of that work in the last few years have been looking at mobile-enabled sites. So for example, we have one developed recently called Splash, which is all about bathing water quality. So it was felt this was a good example to develop a mobile application where people who, we do occasionally have good weather in Ireland, if they're planning a day at the beach, you have a very simple application there that gives you real-time information on the water quality, so that you know if you're going to a particular beach, what the quality is and whether it's open, and you get all that instantaneously. So that mobile view of the world is something that we've started to look at more recently. And we ventured a little bit into the area of app development, but not a huge amount. But a good example is one that we developed or had developed for us called See Something, Say Something, which enables members of the public, if they see a pollution incident or some kind of incident that they want to report, they can take a photograph of it. That will automatically capture the location, and then the details are sent to the appropriate local authority. So there's a fair amount of it is automated, but it's facilitating the public to be able to directly report incidents that they want to notify people about. So the benefits of us using ICT, I think it's fairly obvious, and a big driver within the public sector in Ireland in recent years with the economic downturn has been around driving efficiency. So we've been trying to do a lot more with less. There's been an embargo on staff recruitment until very recently, so even as people left or retired, we weren't able to replace them. So that's been another driver in doing more work automatically where we can, moving away from manual effort, looking as well to maximize the use of the data that we collect. So it is costly and it is public money that we're using, and we want to make sure that we maximize the return. So integrating and generating additional insight from data is a core driver in a lot of what we do. But it's also a key enabler for us to be able to engage with the public. So we're able to make information much more accessible, much more readily available than if it was collected in a paper format. So that's a key driver as well. And if we think about public access, so the EPA is very committed to being open and accessible and having all our information available. So the website, the EPA website, is used as the primary mechanism for that, but we've also explored some other avenues such as YouTube and Twitter and various aspects of social media to try and drive some level of engagement, but the website would still be our primary form. So all the license application and enforcement files are available to the public to view. But there's a lot of legislation that covers public information as well, and some of the key ones would be the access to information on the environment and freedom of information. And we do make information available. There are standard or set processes. If people can't find what they want, or we haven't published it for whatever reason, there are mechanisms for people to contact the EPA and look for that detail. The numbers that we actually get, the numbers of those requests are very low, well, relatively low, I think. So under FOI in recent years, we've only had around 5 or 6 queries per year, which I think is quite low. For access to information on the environment, they've been around 30 to 35 requests over recent years. Majority of cases, the requests are granted, but in some cases they're not, around 20%, and that would be because we don't actually have the information or we've already published it. So I think that raises some questions about how we're making the information available if we already have but people can't find it, and that's something that we're starting to look at as an organisation to see how can we do that better. So just to conclude then, I suppose some aspects of the work we do that I think may be relevant to the panel here and for discussion. To call out, one is around the submissions on licence applications. So as part of the process for approving a licence, there is opportunity for the public to comment or provide a submission on it. And in many cases, this involves a dialogue between the EPA and the submitter. In some cases, a submission might be made in the heat of the moment. People are quite aggravated, or the language they might use will be intemperate, and we have a duty to make sure that whatever is published isn't going to defame anyone, that it is based on actual facts. And so there is some dialogue that we have to engage in with people who submit comments on a licence application in some instances. Another aspect that is perhaps more concerning is where people who want to make a very strong case to object to something will provide us with their medical records. So they want to object on health grounds, for example. And anything that gets submitted to us does become part of the public record. And that is clearly stated in everything that we have online. But again, in the heat of the moment, people may not actually realise that. So we do have an engagement, a dialogue with people to make sure that they understand, sending in medical information is obviously very personal information, and anything that we do publish, once it's published, it becomes part of the record. So, there's aspects of our engagement there that we're looking at to see how can we prevent people actually sending us that type of information in the first place, because we really don't, it's not appropriate to be publishing that sort of information. But anything that does become part of a submission, it does become part of the public record, and at the moment there is no way for us to remove that, or there's no mechanism in place, so it is there forever. So if 5, 10, 15 years time somebody decides an objection they made 15 years ago that they want to withdraw it, there's actually no mechanism in place that can happen at the moment. So, if you do a search on somebody's name, it may come up that they've actually made that objection, and they may not want that to come up for whatever reason in the future. So that's an aspect that we're starting to look at, and look at what other organisations do and if there's mechanisms to handle that. But the converse of that, I suppose, is that we also have a complaints process, or an opportunity for people, if they believe a regulated entity is not complying with the terms of their licence, that there is a mechanism there that they can make complaints and let us know where they think the licence conditions are being breached. And in those kinds of instances, people can request that their details remain confidential, that it's not revealed who has actually made the complaint or who has brought that to the EPA. And in those instances, we again have a duty to make sure that we're protecting that person's identity, that it's not revealed, even if the regulated entity will come to us and try and find out who actually made the complaint, where are they coming from, etc. So that's, if you like, a converse of the first issue. But I suppose from an EPA perspective, as I've said, public access is a key driver, and it's something that is very important to the agency. But we recognise that we're perhaps not really engaging with the public in the right way. We make a lot of information available. If you look at our website, there's lots of detailed reports and data and maps, etc. up there. But we haven't really taken the time to date to really assess who our users are, who our customers are, and what is it that they actually want. And this is a dialogue that we're starting to have internally to try and gain a greater understanding of how we can better actually make information available. The fact that we get requests under FOI or AIE looking for information that we've already published indicates that people just don't know how to access it or where to go. And we have looked at social media, but there's actually, we know that it does drive usage, but there are elements to that maybe it's not the right kind of usage. We want to have a more engaged relationship with people, and we need to look at better ways of doing that. So I'll close with that and hand back to Raphaël. Thank you.
Okay, thank you very much, Martina, and also thank you very much for your impeccable time management. So I will now give the floor to Andrew. So please, Andrew, the floor is yours.
Thanks, Raphaël. I'm going to be talking about Earth observation for environmental enforcement. I'm a lawyer working for an NGO in Ireland called Taisce. So my job essentially is to, with very limited resources, try to do what I can to get public authorities in Ireland to enforce the law effectively, and where third-party enforcement rights exist, that would allow us as an NGO to take action directly to use those powers effectively. And there are three broad types of technology that might be of relevance here: satellite data, so-called drones, unmanned aircraft, and then aerial photography, so hiring a small plane and flying over sites and taking photos. I'm actually going to speak about satellite data and aerial photography and not drones. I see there's a specific session, a panel on Friday all about drones. I do know a little bit about using drones for environmental enforcement, so if anyone has any questions, I could try to answer those. I just haven't used them yet directly in my own work. Now, the potential privacy implications of Earth observation technologies hit home to me in a very personal way last year when a man turned up at my door with this photograph and wanted to sell me the photograph of my house. And I succumbed and I purchased the photo. And I took this, it's not particularly clear because I took this on my iPhone of the hard copy, so you're just going to have to take my word for it that the red circle includes 3 readily identifiable individuals, as well as 3 cars that are quite recognizable. Now, luckily, it turned out that those individuals were my parents and one of my children. Equally luckily, it wasn't my wife and one of her boyfriends, which would have been very awkward for everyone concerned. And I should probably say, since this is being recorded, that my wife doesn't have a boyfriend, at least as far as I'm aware. But the point is clear. Flying over sites, taking photos of them, using satellite images that are of sufficiently high resolution can raise privacy issues. Now, I should just say before moving off that in the environmental enforcement context, it's unlikely that one would be relying on photos of family homes. Nevertheless, often one would be relying on images of private property, and that can equally raise privacy considerations. So by way of general introduction, high-resolution Earth observation data from satellites is increasingly available. I'm sure you've all seen Google Earth and what that can provide. And commercial services provide that sort of data, but for many more dates than Google Earth makes available. This sort of data can be very useful in public interest cases. So, for example, in human rights cases, I saw recently the recent Boko Haram massacre of more than 2,000. I saw an article, I think, in the Guardian newspaper, which was using satellite data to record the details of that massacre. Planning and environment cases, which I'm going to talk about, criminal cases, insurance fraud, boundary disputes between neighbours, and then agricultural fraud, where, for example, farmers are claiming subsidies in circumstances where they shouldn't be, in respect of land that they shouldn't be, and so on. There are several barriers, at least ones that I've become aware of, in terms of making use of this sort of data. The first is a knowledge or expertise gap. So I know how to access Google Earth, and I can find images from that of pieces of land. I don't really know how to go about accessing images from other providers of Earth observation data. Then there's the question of the availability of data for specific dates and times. And I've heard from people who are quite heavily involved in this area that, for example, in insurance or road traffic situations, often people will come to satellite data providers and say, I want an image of this accident happening, you know, or the seconds before and the seconds after. So there is an issue about what is available, what's out there. Google Earth provides images of the Earth on a particular date, which can be useful, but if you're looking for something on a very particular date or a particular time, that can be more difficult. Then there's the question of certification for court use. So it's all very well to find an image that's of use to you from Google Earth or another provider. There's then the question of whether you can actually use that in court as evidence, because the judge may look at it and say, okay, I can see you've taken a screen grab from Google Earth. Do you have permission to use it? How do I know that it shows the land you say it does? How do I know it's the date and time you say it is? And how do I know that you haven't altered the image since you took the screen grab? So there are those sorts of questions. And then there's the question of cost, both in terms of buying the images that are out there and maybe paying for someone's time to find the images for you and to certify them for court use. It is a rapidly changing field, it's fair to say, and the rapid changes are addressing some of these barriers I've mentioned. So just a couple of things that might be of particular interest. There's a recent startup, for example, called Planet Labs, which by the middle of this year will have launched more than 130 toaster-sized satellites. And you can see one of the founders holding one of these satellites in the slide here. There are already 71 or so up there. And the plan of Planet Labs is to image the entire Earth every day and then to make those images available commercially. And they see public interest uses for these images as well, and it's yet to be seen whether they will provide particular deals for NGOs working on public interest matters. Operating in a similar space is a company called Skybox Imaging, which was recently acquired by Google. And it has a smaller number of larger satellites and is aiming to provide high-definition images, higher definition than Planet Labs will provide, including 90-second video clips of any place on Earth multiple times per day. And the final development, which I think is particularly interesting, is the establishment late last year of a company in the UK called Air and Space Evidence Limited, which is described by the press as the world's first space detective agency. And what it does, it fills the gap I mentioned about certification and sourcing of images. So it specializes in providing Earth observation data for use as evidence in legal and insurance cases. In the environmental context, I have found four main uses for satellite data and aerial photography. The first is to check whether people and companies are complying with legislation. The second is to use as evidence where the question, when did something happen? You know, when did a particular environmentally damaging incident happen? If I need to evidence that, satellite data can be extremely useful. The third is to give a very clear visual representation of damage or environmental change. And this aerial photography can be hugely useful in this regard. I've seen cases where report after report has been produced saying, for example, there has been a 99% loss in a particular habitat type over a particular period, and regulators have not taken action, and then a 20-page report is produced with some excellent aerial photographs that passes up the chain, and someone says, you know what, this is really meaningful to my work, and I can see what's happening here. And finally, Earth observation data is particularly useful where getting access to the land is an issue. And one thing that may not arise in your own work, but does in the context of environmental enforcement work, particularly I think when you're working with an NGO, is the issue of well, gaining access, but also sort of threats and intimidation and people not wanting you to enforce. So the image I've provided there is one which arose in light of a particularly contentious dispute in Ireland, and 1 year a bunch of environmental NGO representatives visited some sites where damage was being done on foot and produced a report to the European Commission, which led to legal infringement action. And then it was a seasonal activity. In the closed period, they were effectively warned, you know, don't go back next year on foot. It won't be safe for you to do that. So it then became, and the image you can see here is it speaks for itself, I think, which was a post from Facebook. Their Earth observation data becomes very useful. Satellite images and aerial photography, they tend to accompany other evidence, maybe ground truthing, or satellite data might be paired with aerial photography, where you can get you know because you took the images exactly when they were taken and so on, rather than satellite data standing alone. A couple of cases to mention that I have been working on. The first is a wetland in County Clare in the west of Ireland, and I've outlined the wetland in pink here, which shows the site, this is from Google Earth, shows the site in January 2010. This is zooming in just on the western part of the site. You can see it was unaltered in January 2010. And then aerial photos taken in October 2014 show that the site is subject to ongoing infilling. So that raises questions about whether this is permitted and so on. And here's a second case, which is unregulated industrial peat extraction, where the temporal aspect was important. When did this happen? Because there might be an argument that it could escape regulation if it was happening before 1964, but the aerial images can show that it was intact in 73 and is now heavily under extraction. In terms of privacy issues and using this data, privacy has been described by Ray Purdy, an academic who's active in this field, as the elephant in the room. As he says, we're in the somewhat uncomfortable position where often fully commercial companies are controlling a potentially invasive technology relatively unregulated. There are international agreements out there covering space technologies, but they were negotiated at a time when high-definition images were not readily available commercially to the public. And so they don't capture the sorts of things that you might want them to in terms of privacy. Until recently, an informal agreement between the US and France set 50 centimeters, a 50 centimeter restriction on spatial resolution for commercially available satellite images. But very recently, the US government decided to lift this restriction, allowing for a resolution of up to 31 centimeters, and that apparently will allow clear vision of manholes and mailboxes. So as spatial resolution improves and the frequency of use increases, I think these sorts of privacy issues that I flagged at the start are likely to become of increasing importance. It's important to say that the courts have often found that aerial photography is not an unlawful invasion of privacy, although much will depend on the facts. And the question arises, is satellite data likely to be more or less intrusive than aerial photography? And again, that would depend on the facts, but where you're taking images from directly above, where you're not taking images of the family home, where they're not at particularly high resolution, you'd imagine there'll be less scope for privacy problems. Setting the moral question to one side, legally data could be excluded as evidence in court where privacy rights have been breached. And so that's a particular issue for lawyers working on cases. But it's only a matter of time, I think, before privacy arguments come to be raised regularly in court where satellite images are used as evidence. And we can already see the sort of framework for the argument under, at least within the EU, under the Charter of Fundamental Rights. So is there an interference with a fundamental right? The one most relevant would probably be Article 7, right to private life. In the environmental context, is there an Article 52(1) justification, which would justify the interference with the right? And the final thing, which I noticed from the Digital Rights Ireland judgment of the European Court, was this interesting quote in the context of what private satellite companies are doing now, you know, capturing images, multiple images every day of every area of the Earth. As the court said in this case, the fact the data are retained and subsequently used without the subscriber or registered user being informed is likely to generate in the minds of the persons concerned the feeling that their private lives are the subject of constant surveillance. And just to conclude, I think it's an area that is crying out for international discussion and international regulation, and there is this window of opportunity, maybe, as Ray Purdy has said in an article, before the technology explodes beyond the capacity for it to be effectively regulated. Thank you.
Okay, thank you very much. Thank you very much, Andrew, for this very interesting presentation that I think really put together both the environmental uses of ICT and the privacy issues we're looking at. So I think now it's time for Burkhard, and yeah, you don't have slides, I think.
Oops. Okay, let me tell you a story. Some of the details have been changed to protect the innocent and also to make it more exciting for you. Moved recently in a very, very nice, leafy suburb of one of the most beautiful cities in Europe, in Edinburgh. Very, very cozy there. It's still in bus ride distance to the city center, but you're also more or less direct in the Pentland Hills and free nature. There's only one small problem, something that makes it slightly less agreeable than it could be. It's relatively near to the bypass, so there's quite a lot of noise pollution. Now, some neighbors, all very, very nice neighbors in this really, really nice leafy suburb, decided to do something about it. One of them a retired academic, one of them a retired council worker. They decided we can use crowdsourcing to find out what the noise pollution exactly is, make a submission to the council, and maybe get some noise protection walls installed. So they put their collective intelligence together, designed some apps, got hold of some unused technology from the university, and equipped us all with the capacity to record noise pollution from the bypass, which we duly submitted to the council, and hopefully something will be done. Now, great story, isn't it? Highlights the power of grassroots activity supported by ICT to bring about a better environment. And for about an hour, I felt really, really good about myself, which doesn't happen that often these days. And unfortunately, immediately afterwards, my usual academic cynicism kicked in, and I said, well, was that actually quite as a success story as it initially appeared to me? First, it looks like it, exactly the sort of thing Martina describes. We reduced the cost for the local authority in times of austerity. We took on some of the measuring. It was high quality, it was reliable, and it involved better planning, better resource allocation. Then I thought, well, what enabled us to do this? What were the driving forces? Well, one thing was we had in this nice little suburb probably one of the highest percentage of active and retired academics in Edinburgh. Throw a brick and you probably kill 3 chairs. We have lots of pensioners who still retired under the more generous old pension system, so they don't have to work in their old age, and they have time at their hands. They can set up citizen initiatives. There is a lot of social capital available, lots of people who agree in principle of what makes a good life and are willing to act on this. So we were already extremely, extremely, extremely privileged, and that allowed us to do this. Now, a bit further down the road and much, much closer to the bypass, for some strange reason, there are our high-rising buildings and the problem spots of Edinburgh. They are probably having a considerably higher level of noise pollution, but they don't have the social capital available to make this type of initiative, this type of recording. And because of that, the council doesn't necessarily know what's going on there, and because of that, they do not necessarily direct their scarce resources where objectively they maybe ought to be. So that got me thinking a little bit more about, on the one hand, the benefits of ICT for environmental regulation, but also of the hazards that we are facing. Everyone talks about big data. One of the things about big data is that the individual, in a way, doesn't matter any longer because statistically it all evens out at the end of the day. But that makes it even more likely and more difficult to spot when systematically certain groups are overlooked. The digitally rich, the gadget rich, people who have a huge digital footprint, they will be the ones who feed even more into policy making or decision making on company level. Those who are already disadvantaged will also typically be gadget poor, will as a result have a lower data footprint and might as a result lose out on crucial decision making. That is, I think, already a problem within Europe, within developed nations. It becomes even more of a problem, I fear, when we look at international context, developing countries, where targets are set by international organizations dominated by influential Western donors about meeting environmental targets. And on the back of that, in countries which might have very problematic political internal situations, ICT systems are set up for monitoring, which again can be highly selective. You mentioned the Boko Haram pictures from the satellite. That is great for prosecution in that case, but why were these parts photographed and not others? Can we be certain, can we be confident that the governments who control the satellites or who will control the ICT infrastructure even try to give a fair and accurate account? And even if they try, will there still be within these countries populations who are systematically not able to make their voice heard, not being able to get their data fed into the new decision-making process? I mean, after all, even in developing countries, or especially in developing countries, we often face a particularly huge discrepancy between the very rich and affluent and the most poor and neglected. So if you go to places like Africa, but also parts of Latin America, you get obviously a significant digital footprint in some of the big cities, much, much less of that in the slums that grow around them. If we use this type of data to direct resources, are we in danger of benefiting those most that already are in the most positive and affluent position, while neglecting those whose data is not generated or does not feed into that type of decision-making process? So that is my concern at the moment, or well, not a concern, but I think something we as academics ought to look into as we explore the advantages of ICT for environmental regulation. It is great that we start to think about the privacy implications right at the beginning of this new technology, but I think this aspect shouldn't be overlooked. And I think, and that might be more difficult to argue, that it is a genuine part of what our community as data protection and privacy lawyers ought to be interested in. Not being heard, not having your data being taken into account is a privacy issue if we have a richer notion of what privacy actually is. There's one narrative in privacy and data protection law that tries to reduce it to a right that is not necessarily antisocial but asocial. It's a purely protective right against powerful entities like states and companies, and its only function is to prevent us or prevent others from getting access to our data. It is purely defensive. It is purely about exclusion or excluding some groups from accessing information. I think that conception of privacy is falling short of what privacy ought to be all about. It resonates a little bit, I always felt, with George Orwell, 1984. Proles and animals are free. In that sense, people who are too poor to generate data would be the ones whose privacy is the most protected in the new world of big data. I don't think that is true. It is as cynically untrue or as cynical an approach to data protection as the one Orwell described when he came up with that slogan. Rather, what privacy ought to be about is not just excluding access to data, but giving control over data, enabling intentional sharing as opposed to a situation where I cannot make the decision to share my data because it is already known by everyone. My colleague in Edinburgh, Charles Raab, put it like this. We value personal autonomy, self-determination, and privacy, or they are important not primarily because individuals may wish to live in isolation, for they do not mostly, but so that they can participate in social and political relationships at various levels of scale, and so that they can undertake projects and pursue their own goals. So privacy, in that sense, is not just about denying others access to my data, but putting me in control of my data so that I can share it in ways that are beneficial for me, but also for the polity I am a member of. It is a fundamental right that enables other important values like democracy, like societal participation. And if we have a thicker notion of privacy like that, questions of digital divide do become something that falls into our remit. Issues of excluding certain subjects systematically from being recorded, from contributing to the wealth of data that we amass, then becomes as much of a privacy issue as overly intrusive surveillance and overly intrusive collection of data that others are subject to. So from a legal perspective, to a certain degree, the forthcoming European data regulation takes up some of these themes by emphasizing things like data portability, putting people in charge, by emphasizing the importance of power differentials. But I think we have to think much, much more radically about these issues when it comes in particular to environmental regulation as a public good, to ensure that when we design the ICT system that enable enforcement and enable us to allow citizens in a much greater scale than before to inform decision makers about their needs, the environmental problems that they face, that we do not systematically exclude the very people that are already those who are most likely to suffer from environmental degradation. And I'm actually already finished now, so we'll save some time at the end.
Perfect, yes. Okay, so thank you very much. And I will now give the floor to Guido, so maybe you want to sit here so you can control your slides.
Yeah, oh, no, it works. Thank you very much for inviting me. So I'm going to give a rather theoretical presentation on the issue of smart meters, privacy responsibility under the idea of responsible research and innovation. Why I want to examine this issue because it is not on the slides, but I assume that many people here are already familiar with the problem. Yes, sometimes it doesn't work. Which is, smart meters are developed in order to achieve some important environmental goals, like greener economy, better energy consumption, and so on. So the development of smart meters is intended to achieve some important political and also, if you want, ethical goals in one way. So it's kind of linked with a positive outcome. On the other hand, there's a problem of privacy because smart meters are devices which collect and communicate a lot of personal data, and that can pose problems of privacy concern because as the smart meters implementation is required by European legislation, it will be increasingly growing in the next 10 years, I think. The possibility is that a lot of data of individual users will be available to authorities, but also to private parties. So the problem is that of kind of controlling the everyday life of citizens. So we have two competing goals, or two competing targets, if you want. In one side, we have the environmental goals, and legitimate and even promoted by European legislation. But on the other hand, we have the issues of privacy protection. So we are in a case where we have to balance two different interests and different principles. And this is where the idea of responsible research innovation comes into play. So why I think that is interesting to talk about RRI, which is the acronym of Responsible Research Innovation, because it's a concept who expresses the ambition to integrate broader societal needs within the development of scientific innovation, and considering also ethical and social aspects of the innovation process. And so RRI goes beyond the traditional approaches to responsibility, at least legal approaches to responsibility, which are mainly linked with dealing with traditional notions like liability, accountability, sanction, and so on, which is a ex post facto responsibility. So what definition, I skipped the definition of responsible research innovation. I mean, what is interesting in responsible research innovation is that it takes responsibility beyond the idea of risk regulation and tries to move from a basic idea of backward-looking responsibility, the traditional one, to a forward-looking responsibility linked to different ideas. So the backward-looking responsibility is the responsibility connected with the ideas fault, guilt, punishment, etc. Forward-looking idea of responsibility is linked to ideas of risk, precaution, and responsible innovation. I will go back, yes. So here I'm sorry for the order of the slides. So what's particular responsible innovation? Is that it's defined as a interactive process, transparent process, where societal actors and innovators become mutually responsive to each other with a view on ethical acceptability, sustainability, and societal desirability of innovation process and products. So what is interesting is that our idea reshapes in somehow the idea of responsibility with 2 or 3 characteristics, which are mutual responsibility. There's a two-way process of responsibility, a communication process and responsibility, and responsibility is oriented towards future. Okay, so what a responsibility oriented towards future is what is called in literature prospective responsibility. And this kind of responsibility is linked mainly to the ideas of roles and tasks. So having a role or a task to perform in the future. And this kind of responsibility, at least in legal thought, has been for a long time considered as a derivative form of the retrospective or backward-looking responsibility. So for a long time, talking about a prospective responsibility was considered as being the same as talking about duty, and no more than complying with a duty. But in fact, if we see what are the regulatory strategies that RRI approach, at least in the European policy making, tries to implement, we see that responsibility here is based on the idea of responsibilization, which is a kind of active responsibility rather than a passive one. Responsibilization means predisposing actors to assume responsibility for their action. And if we want to have a better insight, responsibility in this sense is in contrast with a mere compliance with rules, presupposes the care for duties and uncoerced, let's say voluntary application of certain values and the root motivation for action. So we have 2 characters emerging, which is an early commitment, so an anticipation of responsibility somehow, and voluntary application of regulatory standards. I've taken this analysis from Luigi Pellizzoni. I cannot explain everything. He is showing how what is the sense of the evolution of responsibility within environmental governance, and he stresses. We have not the time to argue, to explain, but what he wants to stress is that responsibility is moving from traditional liability towards responsiveness. So in environmental governance, we can see that the form of realization of responsibility is that of responsiveness. Responsiveness is the word a kind of new word is not new is not a legal word, and is indicated to used to indicate this active side of responsibility. So if we want to try to understand a bit the evolution of responsibility, okay, the table is a bit complicated, but we can distinguish different paradigms of responsibility, and we can say there are four big main paradigms of responsibility. The traditional one is the one where responsibility is linked with fault. Then we have the solidarity paradigm, where responsibility is linked to risk, and then to risk assessment and the risk management, etc. Then we have the precautionary paradigm, where responsibility is linked to uncertainty, and this was the first big change towards an active and anticipatory and prospective idea of responsibility. And then we have this responsible research innovation paradigm, which is still ongoing, and where explicitly we have responsibilities linked with a proactionary approach, so anticipating, but going beyond the mere compliance with legal duty, and where responsiveness is a key feature for implementation, practical implementation of this form of responsibility. So I try to connect the idea of an active responsibility and RRI with the smartness of the device, because we assume that smart meters and smart grids are smart because of technical feature of the device itself. What I think that smartness is not just a technical feature, but involves normative assumptions, decisions, values, and user acceptance. Yes, maybe I switch the device. I hope this is smarter, yes. So we can say that smartness is also a social construct, and it's related to the design, the use, the acceptance, and the goals. So design of and the use of the device, the acceptance of the device by the public, and also the goals which the device have to fulfill. So smartness, we can say, is therefore contextual, like privacy. It's a very known thesis from Martina that privacy is contextual. So privacy is not the same. It changes depending on the context. And smartness is more or less the same. And the same goes with responsibility, because responsiveness as being ready to undertake, to anticipate, and to be open to the need of the others is linked to the context and to the contestation and the co-definition, contestation of values, competing values, and the co-definition of what are the goals that we can achieve. I'm finishing, sorry. I try to also think about what can be the practical implication of those abstract ideas that I talked about in 10 minutes. I think that, in practically speaking, this could lead to some technical solutions, which is like the use of open source software and hardware, or reusable data format, long-term accessibility, interoperability standards, and so on. Pragmatically speaking, so from a user perspective, we can balance these privacy issues by using privacy-enhancing technologies, and on the public side, by implementing transparency. So the more the data processing and use is transparent, the more the people will be responsive, in the sense they will be willing to share their data. And what is more problematic is that probably this is one of the problems, is that the smart meters should be able to resist the changing conceptions of privacy. This could be a real problem, and should be so designed in order to be adaptive to changes in conceptions of privacy. So not only foreseeable problems, but also in the future concerns that we don't know now. So as the last words, I was thinking in legal terms: should the smart meters be like legal, like it's often said of legal norms, defeasible by design? It's often said that legal rules are defeasible in the sense that it's possible to find implied exceptions that cannot often be specified in advance. So should be there for smart meters also. Thank you.
No, thank you very much, Guido. So I think we have now 15 minutes left. So maybe Rónán, you want to ask a quick round of questions, and then we can take a few questions from the public.
Thanks very much, Raphaël. I have a number of different questions which sort of cross over between some of the different panelists. So I'll throw them out and I'll see who wants to pick them up and run with them. But one of the things that struck me about what both Martina and Andrew were talking about was the extent to which I think also connects actually with what Guido was saying at the end, that both the state and NGOs may end up capturing a lot of data, which is not really necessary for their immediate purpose, which may then have privacy implications. So I'm wondering if either of those two might want to comment on the extent to which, to a certain extent, I'm asking out of ignorance because I don't know to what extent would the EPA have data which they may be required to release under access to environmental information, or FOI, which could have privacy implications. To what extent do you think about that? And then maybe Andrew, from your perspective, using something like aerial photography and Earth observation, to what extent can you ensure that you only actually capture what you want and you're not inadvertently breaching the privacy of either the people whose activities you're investigating or people who just happen to be, nearby at that time?
Do you want me to take the first one?
Sure.
So it's something that we are aware of, and we acknowledge the fact that even in an organization that we're relatively small, with 340 people or so, we recognize that different parts of the organization can be going out to the same company, the same licensee, the same entity, and asking for different aspects of the same type of data, if you like. And it's something that internally we're reviewing all our license formats, if you like, in a way that we can standardize and agree what is the absolute minimum level of information that we should be asking for. It's a principle. We shouldn't be asking for anything that we don't actually need, that we shouldn't be asking, and we shouldn't be storing anything that isn't essential to the work that we need to do. But over time, and for various reasons, as new legislation has been introduced and different requirements have evolved in different areas, it does vary across the organization what we're going out and asking for. So there is a review underway at the moment to try and see how can we align and standardize and minimize the amount of engagement and build this kind of customer-centric view, so that we all know what we've already got and what we've already asked for, and then we're not going out and duplicating that. In terms of privacy, I mean, most of what we collect is environmental in essence, and that is available for the large part. Anything to do with a license and enforcement activities is publicly available and accessible. And then under FOI and AIE, anything that we haven't published, and sometimes that is just a matter of time that we haven't quite got round to it, that is then made available. So I don't think there are any significant issues in relation to the question, the specific question that you're asking about, but it is something that we are reviewing.
Thanks. Andrew, do you want to make any comments on that?
Well, the first thing to say is that we don't very regularly collect, for example, aerial photography data, because it's relatively expensive for a charity. It costs about €300 per hour to hire a small plane with a pilot and fly around and take photos yourself. So we wouldn't hold very much data, and the things that we are taking photos of are pretty clearly targeted in advance, because we want to minimize the amount of time we spend in the air and minimize the cost. And I would be fairly confident that the images that we are taking do not represent an infringement on the right to privacy. And in circumstances where individuals might be photographed, we would take just a judgment call for right or wrong not to use those photos in reports and so on. So, you know, that's just the approach we take to it. We are sensitive to the potential issues, but I think there would be a good argument in circumstances of environmental damage on private land but not featuring family home, that there's not an infringement of the privacy right, and to the extent that there might be an argument that there was, I think there could be a decent argument that there is a justification for the infringement.
Okay, so you take all these issues into account already in terms of your procedures?
We try to.
Okay. My last question then, again, kind of a broad thing aimed at Burkhard and Guido sort of together. I suppose my starting point for the question is this word of smart. I wonder often to what extent we use that label appropriately. I'm not sure how smart a lot of this technology really is. And I was particularly struck by one of the things that Burkhard seemed to be arguing for, which is that we should have quite fine control over our data and how we reveal it and when we reveal it and how it's to be used. And I'm just wondering to what extent that's really possible or feasible in terms of, first of all, the actual sophistication of the technology in terms of something like Earth observation or noise pollution sensors or whatever, but also the argument that Guido seemed to be making, which is the voluntary application of open standards, open source, and so on by commercial companies. The reality is that a lot of the technology that's underlying the kind of regulatory apparatus that we're talking about here comes from the commercial world, and they're really not going to be keen to give up the thing that makes them, that provides them with an income stream and allows them to continue to exist. So I guess I just query that use of smart and the extent to which we can realistically expect people to voluntarily fall into line with a more nuanced control over privacy. I'm not sure if you want to comment on that.
Okay, I can try the first. Here's that one. Two-part answer, really. Firstly, I think the type of concerns that I had, and I know that is a dangerous argument to make in a privacy conference, is maybe not so much at the point where the data is collected, but the type of use particular public bodies put that data to. So a new form, and we do find this going way back into the 1950s, 1960s in the US, certain types of anti-discrimination legislation, which allows types of judicial review when there's an indirect effect on certain types of prescribed minorities. I think we need to revisit that in the big data landscape so that we find forms of challenging resource allocations, that we are able to challenge certain types of political decisions that are based on big data or data collection, use them as a rationale to challenge them and say, well, it's not so much that the data that you have is wrong, but it is systematically incomplete. It was collected in ways that reinforce inadvertently, not because of some big conspiracy, but simply because of the way digital footprints are unequally distributed. It systematically neglects parts of the population. So it's really at the point of judicial review where these things potentially come in, rather than at the point of more fine-grained control over data. And that leads me potentially to the sort of more philosophically interesting thing when it comes to smartness. And that really was just triggered by your comments, so I speak totally off the cuff. One of the interesting things we humans can do, which is extremely difficult and really requires smartness, is to reason about things that are not there. Reasoning about things that are there, everyone can do that. Even animals can do that. Primates can do that. But to reason about things that are not there, the dogs that did not bark, that is actually quite difficult. So if you think in terms of smart technologies, it is relatively straightforward and not very smart to have a system that says, you have just been recorded, I inform you about that. One of these data control rights. That's simple. What requires a real smartness is even to conceptualize something like, you haven't been recorded, even though you had a reasonable expectation that you were, you might want to keep track of that in some form or other. So reasoning about things that don't exist, reasoning about things that are not there is notoriously difficult. If you go into programming languages, reasoning about absent things gets you into abstract object theory and really, really complicated formal stuff. So that would be real smart. And in that sense, if one takes this idea, yes, we would need a totally different level of smartness in the machines.
Guido, you want to?
Yes, just a few words. Yes, the issue, for me, the issue of the voluntary application of standards, it's a problematic one as well, because in one hand, it ensures this anticipation of and this projection of responsibility towards future, but on the other hand, it's something that sits out of legal framing of responsibility. So this voluntary application poses a lot of problems in terms of how do we grant and we protect privacy and fundamental values with voluntary commitments. This is problematic. So and about smartness, yes, my idea was that. In fact, I was surprised that I was thinking, okay, I'm talking about responsibility, which is a syndrome of concepts, like it's said in literature. And I was thinking, but smart meters are things. So I know what is a smart meter, and I found that there's no agreed definition of what is a smart meter. So this was striking to me. I was asking to myself why. This is exactly because of smartness, and what I try to say, or what I'm keen to think, is that smartness as a social construct is problematic, and it's open-ended. So we have to define, and we have to struggle for being able to define what is smartness, what makes the smartness of the device, and the use of the device. Otherwise, smartness will be just a label and will be imposed a top-down approach, and yes, and then the history will will be the same. Thank you.
Thank you, Guido. Okay, we have about 2 minutes left, so if there are some questions from the audience, this gentleman at the back there.
The open source environmental data comes from, and secondly, the move towards instrumentation of the smart environment, smart city, will lead to large amounts of data being collected, or if maybe it already has been collected and is not observed. And I'm just wondering for the panel, where does the privacy fit into this? In the collection or in the use?
Does anybody want to take that up?
Well, for me, you would get the academic pet answer. It all depends. Certain types of data, certain types of problems are best dealt with at the source, that is at the collection. But I think other problems are still better framed if you look primarily at the use, because only then do you have the right type of mechanisms in place to actually deal with the problem. So I'm afraid it's not a particularly enlightening answer, but to that extent it really depends. What we could possibly come up with is certain types of conceptual correlations. I think certain types of data will be typically problematic at the collection level. Certain types of data will be typically problematic at the application level, and they might not always be overlapping categories. So that might help frame or structure the environment, but I don't think one can say anything more than that.
Thank you, Burkhard. Might take one last question before we get kicked out. Anyone? Okay, yeah, go ahead.
What if the problem only emerges when you've collected all the data and aggregated it and seen the privacy invasive quality of that data? What do you do then?
Do you want to take that, Burkhard, or Guido, maybe from a responsible research innovation? So the question is, what do you do when you don't realize that you have a privacy problem until after you've collected and aggregated the data? That's an RRI issue, I think.
Yes, I'm not a privacy expert, so don't expect me a legal advice. But yes, I mean, in this case, adopting a responsible approach, in my opinion, would be being transparent and maybe declare yourself and pose the question, raise the question, when if you are aware just afterwards that you may have some of your activities of collecting data maybe pose some privacy problems that you haven't foreseen, but then discuss it and disclose at least the problem and be transparent and engage in a dialogue. This could be a way to responsibly undertake the problem, in my opinion.
Okay, very good. I think we're just about out of time, so I'll just hand back over to Raphaël to close the panel up.
Thank you, Rónán. And so I'll just thank again all the speakers for their very interesting presentation and the public for being here. And so yes, thank you very much.